Imagine the moment a solicitor realizes they made an unrecoverable error on a client file, a critical deadline missed, or a fatal contract flaw. When this happens, a solicitor operates under a dual burden. Like anyone else, they must obey the general laws of the country, but they are also bound by an elevated code of ethical conduct. This higher standard exists because of the special relationship between the profession and the justice system. Clients must have total confidence that their solicitor will handle their information and assets ethically. If that trust is broken, it taints the entire system. Because of this, the boundary between legal compliance and ethical conduct is defined by two different sets of rules. Behavior can be entirely legal, yet still constitute professional misconduct under regulatory standards. This creates a unique tension. When a solicitor makes a mistake, the consequences do not travel down a single, simple regulatory pipeline. This flowchart shows the tripartite regulatory framework governing the profession. A single client grievance branches into three distinct jurisdictions: service failures handled by the Legal Ombudsman, professional misconduct overseen by the SRA and the Solicitors Disciplinary Tribunal, and civil negligence adjudicated by the courts. The first pathway is the Legal Ombudsman, or LEO. It functions to handle matters of client service and consumer protection. The second pathway is governed by the Solicitors Regulation Authority and the SDT. They handle professional discipline and ethical breaches, focusing on the solicitor's fitness to practice. The third pathway leads directly to the civil courts. This jurisdiction exists to adjudicate tortious liability and secure financial restitution for the client. Navigating these three distinct jurisdictions is a requirement for the SQE, but it is also the framework for every decision in a solicitor's daily practice. The regulatory service pathway actually begins long before a mistake is made. It starts on day zero, the very moment a client engages a firm. This timeline shows the compliance journey. Under paragraph 8.3 of the Code of Conduct, a solicitor is mandated to provide written notification of the firm's internal complaint procedures and the client's right to escalate to the Legal Ombudsman. When a grievance is filed, there is a mandatory internal countdown. The client must allow the firm 8 weeks to resolve the issue internally before escalating the matter. If that 8-week window expires without a satisfactory resolution, the timeline branches. The client can now officially take their complaint to the Legal Ombudsman. Access to the LEO is reserved for individuals, microenterprises, and specific small charities or trusts. Large corporations are generally excluded from the scheme. The LEO's jurisdiction is focused on service quality, things like unreasonable delays, poor communication, or lost documents. It does not decide whether the solicitor's legal advice was actually correct. This graphic highlights two specific parameters of the LEO. Crucially, notice the second rule. A client does not need to prove actual financial damage to trigger a LEO determination. Subpar service is enough on its own. Because of this focus on service, the LEO exercises non-monetary remedial powers. It can force a firm to issue a formal apology, refund legal fees, or limit future charges. It can also award compensation for inconvenience or the cost of rectifying an error, but this payout cannot exceed £50,000. The LEO exists for consumer service correction and restitution. It has no power to fine or disbar the professional. For issues regarding the profession's internal integrity, the focus shifts to the SRA Principles and the Code of Conduct. Professional misconduct occurs when these core ethical rules are broken. For example, if a solicitor gives a formal undertaking and fails to perform it, they have breached the code. This diagram illustrates the SRA's intake process. When a grievance is reported, the SRA runs it through a 3-step assessment threshold test to decide if a formal investigation is necessary. Gate 1 asks, based on the allegations, is there a potential breach of the SRA standards and regulations? Gate 2 asks, is that potential breach sufficiently serious to warrant regulatory action? And Gate 3 asks, is the breach actually capable of proof? If a case passes all three gates, we look at this jurisdictional sliding scale. On the left are the SRA's internal powers for lower-level infractions, and on the right are SDT prosecutions for severe misconduct. Operating on the left side of the scale, the SRA can issue written rebukes, impose controls on how a solicitor practices, and levy financial penalties, but its fining power for individuals is currently limited to £25,000. If a case involves extreme severity, high public interest, or misappropriation of client money, it exceeds the SRA's internal limits. The SRA must take on the role of prosecutor. They prosecute these cases before the Solicitors Disciplinary Tribunal, or SDT, an independent adjudicating body appointed by the Master of the Rolls. The SDT holds broader disciplinary powers. It can impose unlimited fines, and it alone has the authority to strike a solicitor off the roll. Unlike the consumer-focused Legal Ombudsman, the SRA and SDT pathways are punitive. They are designed to protect the public and maintain trust in the justice system. In practice, these pathways rarely operate in isolation. A single factual error can trigger all three types of liability at once. Look at this Venn diagram mapping the three jurisdictions. If a solicitor misses a statutory deadline to issue litigation proceedings, it lands directly in the center overlap. The civil negligence circle applies when a court finds a breach of the duty of care that resulted in actual, foreseeable financial loss, in this case, the client losing their chance to pursue a claim. When a severe error like this happens, Code of Conduct paragraph 7.11 imposes an immediate ethical obligation on the solicitor. This is the duty of honesty. The solicitor must inform the client, explain the full impact of the mistake, and advise them to seek independent legal advice. Delaying this disclosure to protect the firm's reputation or waiting to consult an insurance provider is an independent ethical violation. The obligation to be open with the client applies regardless of the firm's interests. If the client hires a new solicitor to investigate a negligence claim, the original solicitor must hand over the file, but they are required to retain copies of the original documents for their own reference. For cases where a firm is uninsured or client money has been stolen, this final safety net appears beneath the liability structures, the SRA Compensation Fund. This is a discretionary fund of last resort. It is funded by mandatory contributions from the profession, and grants are capped at £2 million per claim, unless exceptional circumstances apply. The duty of honesty and the compensation fund demonstrate that regulatory compliance prioritizes client transparency and public protection over professional self-preservation. This chart shows the master routing matrix. To analyze any fact pattern, you must keep these three jurisdictions conceptually separated. The Legal Ombudsman compensates for subpar service, does not require proof of financial loss, and is limited to a £50,000 award. The SRA and SDT discipline professional misconduct. The SRA can fine individuals up to £25,000, while the SDT imposes unlimited fines and strikes solicitors off the roll. Finally, civil courts handle tortious claims, requiring evidence of a duty of care and actual foreseeable loss. These overlapping jurisdictions create a system where a single mistake is assessed from the perspectives of the consumer, the profession, and the law. Ethical practice is not achieved merely by avoiding illegal acts. It requires active, continuous judgment that places the client's interests and the integrity of the justice system above the firm. Understanding where these lines are drawn is what allows a solicitor to function effectively as an officer of the court.